The hatchet was found in the yard behind the brothel, still damp. That detail, recorded in the constable's report filed the morning of April 10th, 1836, is the kind of fact that refuses to stay on the page. Still damp. The night had been cool, the kind of cool that settles into lower Manhattan in early April and smells of river mud and horse dung and the particular staleness of streets that never quite dry out. Someone had wiped the blade. Not thoroughly, enough to suggest intention, not enough to suggest time. Inside 41 Thomas Street, on the second floor, in the room at the back, the bed was still burning when Rosina Townsend pushed open the door. What is recorded is that she saw smoke first. Then, as she crossed the threshold with her lamp raised, she saw the bed, a corner of it consumed, the cotton ticking charred. And then she saw Helen Jewett, face down, arms at her sides, the posture so composed that 2 witnesses would later remark, in testimony and in print, that she appeared to be sleeping. She was not sleeping. The left side of her skull had been struck 3 times with something heavy and edged. The coroner, Dr. David Rogers, would note in his examination that 2 of the blows would each, individually, have been sufficient. She was 23 years old. She had been, by multiple accounts, the most widely read, most frequently corresponded with, most carefully dressed woman in any establishment on Thomas or Duane or Mercer Street. She had been, by the same accounts and by the evidence of her own surviving letters, formidably intelligent. None of that was entered into evidence at the trial of Richard P. Robinson. Very little of who she actually was entered into evidence at all. That is the story. Not only the hatchet, though we will come to the hatchet. Not only the 15 minutes, though we will come to those too. The story is the distance, carefully maintained, deliberate, systemic, between what was known about Helen Jewett and what the Court of Public Opinion and the Court of General Sessions decided it was necessary to know. She had a name before the name. She was born Dorcas Doyen in Augusta, Maine, in the year 1813. The parish records confirm the baptism. Beyond that, what survives is partial and sometimes contradictory, which is its own kind of information. Her mother died when she was a child. The exact year is not documented in any record Cohen was able to locate, and she was taken in by the family of Judge Nathan Weston, one of the more prominent legal figures in Augusta at that time. The precise nature of this arrangement, whether it was formal guardianship, domestic service, or the informal fosterage common in early 19th century New England, is not established. What is established is that she lived in the Weston household for several years, had access to their library, and learned to write in a hand that her later correspondents uniformly described as elegant. She was not, in other words, a woman without education. She was a woman without options, which is a different thing entirely, though the newspapers of 1836 showed little interest in the distinction. The transition out of Maine and into sex work in Boston and then New York happened in stages that are only partially reconstructible from the record. What survives with clarity is the destination. By 1833 or 1834 she was working in Boston. By 1835 she had arrived in New York and taken up residence, under the name Helen Jewett, at a succession of establishments before settling at Rosina Townsend's house on Thomas Street. The neighborhood then was in the lower west of the city, close enough to the river that on still days you could hear the water and smell the tar from the shipyards 2 streets over. The house itself was, by the standards of its particular trade, well appointed. Townsend ran an orderly operation. The women who worked there were not street workers. Their clients were merchants, clerks, lawyers' sons, men with some money, or men who wished to appear as though they had it. Richard Robinson had some of both. He was 19 in April of 1836, the son of a comfortable Connecticut family, and had been working as a clerk in the dry goods establishment of Joseph Hoxie on Maiden Lane since the previous year. He was, by newspaper accounts and by the recollections of those who saw him in court, a handsome young man, slight, well-dressed, with the particular self-assurance that comes not from accomplishment, but from the long experience of being treated as though accomplishment is inevitable. He wore on the night of April 9th a long dark cloak. This was noted. It becomes important. He and Helen Jewett had been in correspondence for at least a year before her death. The letters she wrote him survive, or some of them do. They were quoted in the penny press and excerpted by Patricia Klein Cohen from the archives, and they are remarkable documents, not because of their content precisely, though the content is striking, because of their tone. They are the letters of someone who reads carefully and thinks precisely and has opinions about both. They are also, and this is the complication that Helen Jewett's story refuses to resolve neatly, the letters of someone in an arrangement she understood to be partly transactional and partly, or so she allowed herself to believe, something more. In one letter, dated in late 1835, she wrote to Robinson, "You treat me sometimes as though I were nothing, and I find I cannot make myself nothing easily, whatever the convenience." Whether Robinson read that sentence with the attention it deserved is not recorded. What the record does contain is that he continued to visit Thomas Street. He had a pet name for her. She called him Frank in her letters, drawn from the name he sometimes used, Frank Rivers, and she wrote to him with a directness that was, for the period, unusual. She recommended books. She corrected his grammar on at least one documented occasion. She told him when she thought he was wrong. She also, in at least 2 letters, expressed concern about his behavior toward her, a certain coldness that had developed in the months before her death, a sense that something in the nature of their arrangement had shifted without her full understanding of why. What is documented is that by early 1836, Robinson had begun corresponding with at least one other woman, a fact that emerged during pre-trial investigation but received minimal attention during the proceedings themselves. Whether Helen Jewett knew this is not established. Whether it constitutes motive is a question the trial declined to seriously pursue. The evening of April 9th, 1836, a Saturday, is reconstructed from Rosina Townsend's testimony, from the statements of at least 2 other women resident in the house, and from Robinson's own subsequent account, which contradicted the others in several significant particulars. Townsend would testify that Robinson arrived at the house between 10 and 11 in the evening, wearing the long dark cloak. She let him in herself. She knew him. He was a regular visitor, known to the household. She saw him go upstairs to Helen's room. She would testify that she passed by the door at some point between 11 and midnight and heard voices inside, a man's and a woman's. She said, though she could not hear the words, she would testify that she did not see him leave. Sometime before 3 in the morning, she smelled smoke. The cloak was found in the yard near the hatchet. Both were entered into evidence. The hatchet was identified as having been taken probably from the woodpile at the back of the house. It was a household tool, not something brought from outside. The cloak, a distinctive dark broadcloth garment, was identified by Townsend and by at least one other witness as the same cloak Robinson had been wearing when he entered the house. Robinson, arrested the following morning at his boarding house on Day Street, told the officers who came for him, "You are mistaken. I was not there." He said this, according to the officer's account, without particular agitation. He said it the way a man says something he believes will be sufficient. He would continue to say it. Through the arraignment, through the weeks of pre-trial coverage in the penny press, through the trial itself, Richard P. Robinson maintained that he had not been at Thomas Street on the night of April 9th, that he had spent the evening at his boarding house and could prove it, and that the testimony of the women who said otherwise was not to be trusted. The city, in the meantime, had begun to form its opinions. The spring of 1836 in New York City had the particular quality of a place that has grown faster than its own infrastructure can accommodate. The population had more than doubled in the previous 2 decades. The streets below Canal were a dense tangle of commerce and noise and smell, the whole city pushing northward against its own expansion. The penny press, the Herald, the Sun, The transcript had been in existence for only a few years and was still discovering the outer edges of what a newspaper could do to a story and to the people inside it. James Gordon Bennett understood this earlier and more completely than most. Bennett was 40 years old in 1836, a Scotsman who had arrived in America with a good education and a genuine talent for making people read things they hadn't intended to read. He had founded the New York Herald the year before on capital of $500 and an operating principle that was simple and, in retrospect, historically significant. Give people what actually happened, in language they can actually follow, with details that make them feel present at the event. He was not, by the standards of later journalism or earlier, a man of consistent ethical principle. He was, however, a man of enormous professional instinct, and his professional instinct told him on the morning of April 10, 1836, that the murder of Helen Jewett was a story of the first order. He went to the scene himself. This is documented. Bennett wrote about it with a candor that is either admirable or troubling, depending on one's threshold for a man who turned a murdered woman's body into copy. He described in the Herald of April 11th entering the death room. He described the smell, the scent of burnt cotton, and something sweeter beneath it, which we will not here specify. He described the body, and here the line between journalism and exploitation is at its thinnest, with a specificity that was unprecedented in American newspaper coverage. He described her hair spread against the pillow. He described the pallor of her skin, which he compared in a phrase that lodged itself in the public consciousness for weeks, to the marble of a Grecian statue. He did not describe her skull. He did describe her room, the books on the shelf. He named some of them, and they are instructive. Byron, Scott, a volume of letters by Lady Mary Wortley Montagu, a French grammar. The picture that emerged from Bennett's coverage, whatever his intentions in assembling it, was of a woman who had cultivated herself carefully in the time available to her, using the materials available to her, toward ends that no one in any position of authority in 1836 New York was prepared to take seriously. The Herald's circulation doubled in the 2 weeks after the murder. Robinson, during the weeks between his arrest and the trial, was not without support. His employer, Joseph Hoxie, the dry goods merchant, was vocal in his defense, and would become more so. A committee of young clerks, Robinson's peers, and in some cases his friends, organized something between a support movement and a social club around his case. They wore a particular hat, a cap known, in the slang of that season, as a Frank Rivers cap, after Robinson's alias, as a public statement of allegiance. Young men in Manhattan that spring wore these hats in the streets, in the markets, outside the courtroom. The hat has a specific meaning if you hold it long enough. It means the trial had already occurred, in a certain sense, before the jury was seated. It means a significant portion of the male population of New York City had decided, weeks before any evidence was formally weighed, that Robinson was probably innocent, or, more precisely, that whether he was innocent was less important than whether he was one of them. He was one of them. That was the judgment the hats expressed, and from that judgment the rest followed with a kind of terrible logic. The trial opened on June 2nd, 1836, in the Court of General Sessions, before Judge Ogden Edwards. Robinson was represented by Ogden Hoffman. Not a coincidence of names, Hoffman was one of the finest criminal attorneys in the city, a man with a reputation for eloquence and a talent for the particular kind of cross-examination that does not ask questions so much as makes statements in the shape of questions. The prosecution was represented by District Attorney Phoenix, who was not, by the accounts that survive, Hoffman's equal in advocacy or in the tactical understanding of what this particular trial would require. The courtroom was crowded. It was hot. June in lower Manhattan before the era of mechanical ventilation is a particular sensory experience. The smell of bodies and wool, and the sawdust on the floor, and from outside, the constant noise of a city that does not stop for trials. The windows were open because they had to be. The gallery pressed against itself. Men standing where sitting was not possible. Rosina Townsend was called first, or nearly first. She was, of the witnesses the prosecution had, the most important. The woman who had seen Robinson enter, who could identify the cloak, who had found the body. She was also, and the defense knew this before she took the stand, a woman whose professional life could be used to make every word she said seem inherently suspect. Hoffman took her apart methodically. He did not argue that she was lying about the specific facts of that night. Precisely. He argued something more insidious and more effective, that a woman in her position, a woman who ran a house of prostitution, who profited from vice, who had in the very nature of her occupation been required to deceive respectable people for years, was structurally incapable of telling the truth in any meaningful sense. That her word, as a matter of moral taxonomy, belonged in a different category from the word of a respectable person. That the jury should not weigh her testimony against Robinson's alibi witnesses. They should recognize that the two sets of testimony existed in different epistemological registers. He did not say it exactly like that. He was more direct and more devastating. He said in the record as it survives, "She is a woman who has made her living by shamelessness, and you are asked to convict a young man on her shamelessness alone." Townsend, on the stand, did not waver on the core facts. What is recorded is that she was steady. She said she saw Robinson. She said she recognized the cloak. She said she heard voices. She was not shaken by Hoffman on the substance. She was shaken by what being on that stand in that room required of her, to have the fact of what she was named, repeatedly, as though it were the relevant evidence, as though the question before the jury were not who killed Helen Jewett, but whether women like Rosina Townsend were permitted to testify against men like Richard Robinson at all. The other women from the house, Emma French, Mary Gallagher, and at least one other whose name appears in some accounts and not others, testified to similar effect. Each of them had seen Robinson that night, or the cloak, or both. Each of them was subjected to the same process. Hoffman was not cruel in his tone. That is perhaps the most disturbing part of what the transcript reveals. He was professional. He asked questions that were individually reasonable. The cumulative effect was a systematic dismantling, not of their memory of the events of April 9th, but of their standing as human beings capable of memory worth crediting. The alibi witnesses Robinson had produced were, by contrast, treated as unimpeachable. There were two of them, young men, friends and acquaintances, who testified that Robinson had been at his boarding house on Day Street on the evening in question. Their testimony was specific in the way rehearsed testimony is specific, times given with precision, details offered voluntarily, the whole structure a little too neat. The prosecution challenged them. The record shows the challenges were not ineffective. The jury appears not to have weighed them heavily. What the jury weighed, or what the record suggests they weighed, because we cannot know what was said in deliberation, and no account of the deliberation survives, was something that was never formally entered into evidence at all. They weighed what the defense had spent the entire trial establishing by implication, that Richard Robinson was a young man of good family and reasonable prospects, and that the women accusing him were women whose word, by the nature of what they were, could not bind a gentleman. Judge Ogden Edwards' charge to the jury has been analyzed by legal historians and by Patricia Klein-Cohen at length, and the analysis is, each time, more or less the same. Edwards instructed the jury that the alibi witnesses, if believed, were sufficient for acquittal. He spent considerable time on the question of reasonable doubt. He did not instruct the jury to consider the physical evidence, the cloak, the hatchet, the question of how the cloak came to be in the yard if Robinson had not been there, with particular attention. He spent less time than the case warranted on the testimony of the brothel witnesses, and more than the case warranted on the general principle that the prosecution bore the burden of proof. The jury retired. 15 minutes, not 14, not 20. The surviving newspaper accounts are consistent on this point. 15 minutes elapsed between the jury leaving and the jury returning. In that quarter of an hour, 12 men considered the evidence in the murder of Helen Jewett and produced a verdict of not guilty. The mathematics of this are simple and will not leave you alone once you have done them. 15 minutes for 12 men is, if each man was given equal time, 75 seconds per person. That is less time than it takes to read the coroner's description of the wound. Robinson's face, when the verdict was read, is described differently by different accounts. The Herald said he showed no emotion. The Sun said he smiled, briefly, quickly, suppressed. The transcript, which had been more sympathetic to Helen throughout the coverage, said he appeared to be expecting it. The crowd outside, the gallery had overflowed into the street, received the verdict in a way that divided along the lines it had divided all spring. Some cheered, some did not. One account in the Sun, not bylined, noted that a woman standing near the back of the gallery said nothing when the verdict was read. She simply turned and walked out. The reporter did not record her name or say anything further about her. She appears once in the record and then is gone. The city moved on with the particular velocity of cities. The Helen Jewett coverage continued for several weeks in the penny press, and then compressed, and then mostly stopped, the way a fire will when it has consumed what was available to it. Bennett published additional columns, some of them reflective in tone, some of them less so. The hat, the Frank Rivers cap, continued to be worn for a season, and then became the kind of object that is embarrassing to account for later. Robinson left New York within weeks of the acquittal. The record traces him to Texas, where he lived for several decades under a different name. Richard Parmalee, the name appearing in Texas census records and business documents from the 1840s and 1850s. He appears to have done reasonably well. He married. The record does not indicate that he was ever again in difficulty with the law. The law had been, from his perspective, satisfactorily concluded. There are things the subsequent decades produced that the trial of 1836 did not. Scholarship, primarily. Patricia Cline Cohen's work, which restored to Helen Jewett something of the interior life the trial had deliberately excluded, belongs to a category of historical practice that did not exist in 1836 and barely existed for most of the century afterward. The serious reconstruction of the lives of women who left records that no one, at the time, thought it necessary to preserve. The letters that survive, a selection of them, quoted in the newspapers and preserved in archives, are the most direct evidence we have of who Helen Jewett was in her own understanding of herself. In one letter, written to Robinson in the autumn of 1835, roughly 6 months before her death, she described the sensation of reading a book she had particularly admired. She does not name it in the surviving fragment, which is maddening, and said, "I have been in such places before in other books, but this one made me feel I had arrived somewhere for the first time. I should like to feel that again with more books for a long time yet." She was 22 when she wrote it. She was 23 when the hatchet was found, still damp, in the yard. The question the jury did not ask, the question it was not equipped or inclined or required to ask, was this: what did the city lose when it decided that her life could be weighed in 15 minutes and found insufficient? And it is not, finally, a rhetorical question. It is an accounting question. You can do the arithmetic in the record itself. In the pages Cohen spent 3 decades recovering, in the fragment of a letter written by a young woman in Maine who taught herself to read and went to New York and wore silk and read Byron and wrote sentences that outlasted everyone who stood in judgment of her. The hatchet is gone. The cloak is gone. Robinson is gone. The letters remain. She signed them, always, with the name she had chosen for herself, not the name given to her in Augusta, not the name assigned to her by the newspapers, not the name the court used when it referred to her as the deceased. She signed them Helen Jewett, written in the elegant hand that her correspondents always remarked upon, the pen pressed slightly harder at the final letter than at the first. as though she knew that what she left on the page might be the most durable thing she had. She was right.